The Supreme Court of Canada handed down its decision on the constitutionality of the federal carbon tax today, and the federal government won. And so there's a number of provinces like Alberta and Ontario and Saskatchewan who were suing. They lost. So this is a big decision and in support of federal climate policy. And to explain it to us, we're going to talk to Professor Sharon Mascher from the Faculty of Law at the University of Calgary. So welcome to the interview, Sharon.
Thank you very much. It's nice to be here.
Now, let's maybe start with just a brief overview of the decision, please.
Okay, that's easier said than done. It's a really very long decision, a majority of 6, and then 3 dissents, writing separate decisions, and 1 partial dissent and 2 full dissents. And so it's a very complex decision. Undoubtedly, it will be parsed over the coming weeks. But just at a sort of broad, high level, what the majority of the Supreme Court held was that the Greenhouse Gas Pollution Pricing Act sets minimum national standards of GHG price stringency to reduce greenhouse gas emissions. And narrowly defining or characterizing that matter narrowly in that way, the majority held that this legislation was validly enacted under the National Concern Branch of the Peace, Order, and Good Governance clause in Section 91 of the Constitution.
Yeah, I understand that a couple of the minority justices wrote that, that this was not sufficiently like a national crisis to justify peace, order, and good governance. Whereas the majority writer said it's a worldwide crisis. We get it. It's an existential threat to humankind. Like, what more kind of a threat do you need to Canada than that?
Well, that's a really important framing point. Chief Justice Wagner, writing for the majority, starts by saying the essential factual backdrop here, which is uncontested. None of the parties were contesting climate change is real. It's caused by human activities resulting in greenhouse gas emissions, and it poses a grave threat to humanity's future. That was uncontested. That's the starting context. And Chief Justice Wagner also noted, despite some of the submissions from various provinces, he recognized that when this pan-Canadian framework was put in place, of which the carbon price is a piece, many provinces were taking action on climate change, and Alberta, BC, Quebec, Ontario were even taking leadership on carbon pricing. But nevertheless, it was not sufficient action to address the problem or to bring Canada where it needed to be to position it to meet its 2030 emissions reduction commitments. So that's the framing context and the starting place for the majority's decision.
Right, and I understand that the majority decision also pointed out that the federal legislation doesn't dictate to the provinces how they can price carbon. They can have a cap and trade, they can have a carbon tax. They have all sorts of flexibility in the ways they actually want to implement it, which I would think had a substantial impact on the decision the majority came to.
Right. Well, and that fact is really very important, because indeed it is that flexible approach that the Canadian government adopted here in consultation with the provinces, which made this such a complicated piece of legislation. They could easily have been much more heavy-handed, big-footed, with using the criminal law power or their taxation power. But instead, they imbued this plan with flexibility to recognize the early movers and allow provinces choice, and set up legislation as a backstop to say, if you haven't met the minimum stringency requirements for carbon pricing, then the backstop will apply. But otherwise, go ahead and choose if you want a cap and trade or a carbon tax or a hybrid system like Alberta had in place at the time. So that made this a more complex legislative undertaking. Yeah, sorry.
And it sounds like to me, non-lawyer that I am, that the extent to which the dissenting justices, I mean, they wrote their own dissents, and the majority justice wrote a very lengthy explanation, a decision, that this was not a frivolous issue. This was a matter of serious constitutional interpretation. And do you think that the justices did the right thing, and they came in with the majority had the right take on this?
I personally do. In fact, I think in a way they were saving the provinces from themselves in some of the arguments they were making. For example, the provinces largely agreed, and in oral submissions there was given back and forth with the bench, recognizing that the federal government absolutely has criminal law jurisdiction, taxation power, has other powers which would be more heavy-handed. And so the argument was not whether, before the Supreme Court of Canada, was not whether the federal government has constitutional powers to regulate greenhouse gas emissions, but whether this piece of legislation was validly enacted. And had the majority not found that the National Concern Branch could support this legislation, the response from the federal government could well be a more, a flat tax where they collect the revenue, or a clearer carbon pricing mechanism that did not offer the flexibility that this does to the provinces. And so this is the best case scenario for the provinces, I think, as well. And I'm not surprised that there was a split, and I'm not surprised that the majority found that this was, validly enacted under the National Concern Branch.
Could you explain what you mean by validly enacted?
Yes. So in order for federal legislation or provincial legislation to be valid, it has to be supported by a constitutional power. We look to the Constitution Act, and there's several enumerated powers in Section 91 that relate to the federal or to Parliament, and Section 92 that relate to the provinces. The introduction to Section 91 refers to peace, order, and good government, which is where this national concern doctrine comes from. It's rarely used. Normally, we're looking at these enumerated powers. And so that's what the court was asked to say. Is this legislation found within one of the powers that are reserved to the federal government, either because they're explicitly enumerated in Section 91, or because the peace, order, and good government, the national concern doctrine within peace, order, and good government applied here.
Great. Any other final points, Sharon, before we let you go?
Yeah, I think that the majority is very careful to characterize the matter here narrowly. And in deciding that the national concern doctrine appropriately applies, they recognize that there is a provincial inability in and of themselves for provinces to deal with this matter, and that there are consequences for other provinces if one province fails to cooperate. So there's a national concern, there is a need for national consistency. But they also very importantly recognize this double aspect doctrine operates, in that aside from the requirement to meet this minimum pricing stringency standard, the provinces still have the power to regulate greenhouse gas emissions within their provincial jurisdiction. That can be and how their carbon pricing mechanism looks like, and it can be regulation outside of carbon pricing. So it leaves a great deal of room for the provinces still to be proactive and address climate change and greenhouse gas emissions within their jurisdiction.
Sharon, very insightful. Thank you very much for this.
Pleasure.